Good afternoon. Welcome on in to another episode of From Day One. Today we have the court back in session today, a little on the kinky side, as we head on down to court.
Okay, and this will be case 82-23-708489, State of Michigan versus Devontae Turner. Detective, your name for the record, please.
Detective Corporal Mark Johnson, sir. Taylor Police.
Do you swear or affirm the testimony you'll provide in this matter will be true?
Yes, sir.
And are you testifying from personal knowledge or from an investigative report?
From an investigative report, and this will be for Mr. Turner and Mr. Hoffman combined, sir.
Oh, correct. Defendant 2 is Dean Hal Hoffman. Okay, feel free to proceed.
Yes, sir. On 4/18/2023, at approximately 9:50 hours, Taylor officers were dispatched to Cypress on a reported robbery. On arriving at the scene, Corporal Kate spoke with the victim. Smith advised that he had been robbed inside of 65 West Point while being shown the home by an unknown white male. Smith advised that a taken male had then entered with a gun and a knife and robbed him for his wallet, car keys, phone, and wedding ring. The male stole his vehicle and told him to walk to the gas station to retrieve his vehicle. When he walked to the gas station, his vehicle was not there, and he called the police. At the time, officers located Smith's stolen vehicle in front of 6 Cornell. The rest of 6 Cornell advised officers he saw a male exit the vehicle and run westbound back towards West Point Street. Detective Oliver interviewed Smith at the Taylor Police Department. During this time, Smith advised that he was there to meet a male to have intercourse. The white male led him upstairs before making an excuse to leave and exited the house. A male then entered the room with a gun and a knife, assaulted him, pushed him down the stairs before taking his keys, phone, and wedding ring. The male then exited the house and took his vehicle. Based on Smith's description of the white male, Smith was provided a photo lineup. In this lineup, Smith selected Dean Hoffman as the male who led him upstairs. Detectives then executed a search warrant at point and observed a scene consistent with Smith's statement. On 4/19/2023, Detective Oliver was advised by the victim Smith that his stolen credit card had been fraudulently used for a WOW cable bill, Lyft, and a Google account. Detective Oliver contacted WOW and identified the owner of the cable account as Dean Hoffman at 6538 West Point. Detective Oliver then authored a search warrant for that residence. While conducting surveillance at the residence, detectives observed Hoffman and another male, later identified as Devontae Turner, enter into a vehicle after exiting the target residence. The vehicle was driven by a white female. The vehicle was then stopped by uniformed officers and the occupants were ordered out. The occupants were then secured and identified. While conducting a search of the vehicle, officers located Smith's stolen wedding ring under Turner's seat. Detectives then executed the search warrant at 6538 West Point. Inside Hoffman and Turner's room, detectives located stolen Michigan ID credit cards, along with a CO2-powered BB gun and a black baklava-style mask. On 4/20, Detective Oliver interviewed Hoffman under Miranda. Hoffman advised that he's scheduled to meet Smith at 6546 West Point and to hang out. He scheduled the meeting over a dating app over his phone. When Smith got to the location, he led him upstairs. Smith agreed to pay his cable and phone bill if he committed sexual acts on him. While he did not want to do the sexual acts, they began arguing. Hoffman advised that his fiancée Turner was in the house to protect him. After arguing, all three were walking down the stairs, and Turner struck Smith. After Turner hit Smith, Smith fell to the ground and he exited the house. He returned to this point, and Turner returned a few minutes later. Turner provided him with the victim's credit card, and he paid the WOW bill and attempted to use the credit card on Lyft and Google Pay. When they were arrested, they were going to pawn the wedding ring. When asked, Hoffman stated Turner had the BB gun, but he did not know where he put it after the incident. After speaking with Hoffman, Detective Oliver spoke with Turner under Miranda. Turner advised that Hoffman planned to meet Smith at 6 Point. Hoffman went to the house for a short time and then returned back to Point. When Hoffman returned, he could see that he was upset, so he decided to go to West Point and speak with Smith about what had happened. When he entered the house, Smith was upstairs partially naked. He told Smith that it was his house, and he began questioning him about what he was doing. Smith tried to leave, and he continued to pressure him and eventually pushed him, causing him to fall down the stairs. He then advised that while he had a knife in his hand, Smith gave him his car keys. He then exited the house, drove Smith's vehicle to Cornell, stole the change out of the vehicle, and threw the keys underneath it. He then returned to Sig Point. Turner denied being in possession of a BB gun. Speaking with Turner and Hoffman, detectives executed a search warrant on Hoffman's cell phone, which was used by both males. A text conversation on the phone confirmed that Hoffman and Turner had traded Smith's phone for narcotics, and they intended on pawning Smith's wedding ring.
I do find probable cause to sign the warrant, Ms. White.
Rita White on behalf of Mr. Oh, I don't see them in the screen.
Oh, are the defendants there, Detective?
1 second. All right, let me get the jailer to get him in there. I'm sorry about that.
Oh, you guys did have one?
Do you want to run down with Noah? Get them in the poly camera. Hey, is Noah right there? Can you have him take those two guys? Phil's going to come meet him down to the iPad and unmute it. Okay. Sorry about that, Judge. He's getting them right now to put in front of the iPad.
Okay, thank you.
They're in the door.
Good morning, sir. What's your name, please?
Devontae Turner?
All right. And is Mr. Hoffman there as well?
No.
Detective, do you have them both or just one?
Your Honor, did you want both at the same time? Want to do one back to back?
No, we can do them together.
Okay, we'll go grab 1 second.
Okay.
Step up here.
All right. Good morning, sir. What is your name, please?
Dean Hoffman.
Thank you. This will be case 8223-708-489, State of Michigan versus Devontae Turner and Dean Hal Hoffman. Counsel.
Rita White on behalf of Mr. Devontae Turner and Dean Hal Hoffman. Your Honor, I have had a chance to speak with both individuals and have advised them of their rights and the nature of this type of hearing. With that, both will waive formal reading stand mute.
Court will enter a not guilty plea on their behalf as to bond.
With regards to Mr. Turner, he is 30 years old. He represents that he has no prior assaulted felony convictions. He grew up in the state of Ohio. However, he is currently, I believe, residing in Taylor, Michigan. These are serious charges. However, he is aware that there will be a no contact order entered in which he will comply with to have no contact with the complainant on this matter. And Your Honor, with that, we are requesting a very reasonable bond, ideally a personal bond, and if the court so chooses, with tether.
Thank you. Are either of them working?
No. However, Mr. Turner is on parole. I'm not. It hasn't been confirmed whether there has been a flag in terms of a hold being placed on his parole. So no, Mr. Turner is not working, and neither is Mr. Hoffman. But I do want to address bond regarding Hoffman also.
Feel free to do so.
Yes, with regards to Mr. Hoffman, he is 36 years old. He lives with his mother, along with Mr. Turner also lives with the mother of Mr. Hoffman. He does not have any assaultive prior felony convictions, no capious history, along with Mr. Turner, no capious history. They both are aware of the seriousness of this charge, and as a result, either way, they will comply with the bond conditions that the court orders, such as no contact with the complainant, stay out of trouble, and report for all of their court hearings. With that, we are requesting you allow them both to be released on a ideally personal bond, if not a very nominal bond, and if the court so chooses, with tether.
Thank you. And what is Mr. Turner on parole for?
Your Honor, he's on parole for a matter out of Ohio. I believe, is it the weapon charge, Mr. Turner?
Yes.
Okay.
The weapon charge, no assaultive connections to it.
Okay. So, this is pretty concerning. We've got 2 life offenses. armed robbery, carjacking. The way this fact pattern reads is raises a significant amount of concern for this court with regard to safety of the community. Apparently, the complainant was lured into a home under false pretenses and then robbed at gunpoint. And then certain transactions were made fraudulently using his credit cards. It's just. So here's what we'll do. For both defendants, there'll be no contact with the complainant, Mr. Smith. Neither one of you is to possess a firearm or any other dangerous weapon. Should you post bond, you'll both be on GPS tethers on house arrest. If you leave your house, you're going back to jail. Do you both understand all of that?
Yes, Your Honor, but if we're able to, because I was supposed to have an interview on Tuesday, if we're able to be employed, will we be allowed to leave for our job and come back home?
Yes, if you.
Okay, because I have an interview on Tuesday.
All right, if you do get employment, you will be able to go to work only. Other than that, you need to be at home. Is that clear?
Yes, sir.
All right. As to Mr. Turner, being on parole for some sort of gun conviction and then finding himself caught up in this, court will set bond for Mr. Turner at $250,000 cash for surety. And as to Mr. Hoffman, court will set bond at $100,000 cash for surety. Next court dates are May the 1st for probable cause date and May the 8th for preliminary exam, both in 23rd District Court in Taylor. Anything further, counsel?
Your Honor, what does cash surety mean?
It means that you have to post that amount in cash, or you can have a bail bondsman post for you, and they would accept some percentage of that in order to post it.
Your Honor, with regards to both individuals, they have been unable or prohibited from making phone calls. Clearly, we see this bond, they should have free due process to be able to make calls to speak with third parties regarding their bond release. So we're requesting that you make sure the officers allow them to make their phone calls.
Sure. Detective Johnston, can you ensure that they get an opportunity to contact family or someone?
Yes, Your Honor.
Thank you. Anything else for the record?
No, Your Honor.
Okay. Thank you. Thank you, Detective. Have a great day.
Thank you, sir. You as well.
All right, that was a quick one. I did not expect it to be done that fast. One moment, let me see if I can find another quickie. These are long. And this looks to be the shortest from the old court files.
See what happens today.
Numbers 1 and 2, People versus Richard Allen Bass, 2244 FC, 22239 FH.
Jessica Lynch on the FH case. Good afternoon, Your Honor. Amy Baxter, appearing on the 2244 FC matter. Residential assault.
Your Honor, 2244.
Okay.
Richard, station and driver. Richard, can you hear us? Raise your hand if you can hear us, Richard.
May it be shown that the defendant did raise his hand.
There we go. Can you hear us, Mr. Allen Bass? I can hear you. Okay. We're here today. We were here last week. There were a bunch of motions filed, and I think I told you that, we weren't going to proceed because you have a lawyer.
I understand your position on this, but your lawyer did actually file a motion, so I'm going to take that matter up first. So, Mr. Kilwald filed on your behalf a motion for a new trial or a directed verdict. I have had a chance to review that. I'm happy to hear if you want to highlight any arguments, Mr. Kilwald, you may.
Just real quick here. I'll let my motion speak for itself. The only thing I wanted to get to was, again, the reason for the request for a new trial / directed verdict would be Section D. That I don't believe, Your Honor, there was sufficient evidence to support conviction. I understand, Your Honor, you also heard Joanna testify on young little victim. Again, Your Honor, I don't think her testimony. And again, I'm not trying to say she was not truthful, Your Honor, but I'm saying she was a very confused little girl who, for the first 15 or 20 minutes, just sat frozen on a witness stand because all the jurors watching her. That being said, Your Honor, I think there were numerous inconsistencies in her testimony, that I think Your Honor should recognize that based on that, Your Honor, I don't believe the jury should have come to the verdict it did. And I'm asking you for a new trial in this matter. I'm also saying, Your Honor, and I hate saying this because I like you as a judge, I like my client, but there was obviously friction between you and my client. I know my client left some Zoom hearings with all his remarks. And Your Honor, my client believes that you cannot be a fair judge, in whether through the trial or sentencing, Your Honor. And based on that, Your Honor, I'm asking you to grant my client either a directed verdict or a trial. And I'll let my motion speak. The rest of the motion speak for itself.
All right. Ms. Reiser, I haven't had a chance to review your response. You're welcome to highlight anything you wish, and we'll proceed.
Just briefly on what I stated in the motion, in reviewing a motion for a new trial on the ground that the verdict was against the great weight of the evidence, of course, must review the whole body of the proofs, but may not sit as a 13th juror so as to grant a motion based on a disagreement with the credibility determination made by the jury. Not to say that Your Honor would disagree with the jury's verdict here, but that's what Mr. Bass and Mr. Kilwald are asking you to do. And that would be inappropriate in this case, and that's People versus Lemon 456, Mish 1998. Conflicting testimony, even when impeached to some extent, is an insufficient ground for granting a new trial. So I think I would rely on the law that I've stated in my response, that the jury in a criminal sexual conduct first case can convict based on the word of the victim alone. And there was certainly other evidence in this case where the jury was instructed. Jaleila's testimony was clear. It provided a basis for the conviction. And it described the cunnilingus. She identified the defendant. She was under age 13 at the time. He was over age 17. So, and it was a fair trial. The motion that was filed by Mr. Kilwald requesting a new trial just sort of kind of lays out a bunch of unsupported claims, nothing that's supported in the record. The trial was fair. There was an impartial jury selected, and so for the reasons stated in my motion, and when you do the light most favorable to the prosecution, we would ask that you deny.
The matter is before the court on the defendant's motion for a new trial directed verdict. Defendant argues he's entitled to a new trial due to insufficiency of evidence and conflict of interest with the judge. First, as a matter of procedure, the motion is untimely. MCR 6.431A1 states that a motion for a new trial must be filed within 42 days of entry of judgment of sentence, which would be today's date. However, the court will consider the motions on the merit. As to the sufficiency of evidence, there was sufficient evidence upon which a jury could have convicted Mr. Alan Bass. And that was the victim's testimony, which under the law is sufficient evidentiary basis for a conviction. The jury was instructed on how to access credibility before and after the proofs were placed on the record. As a matter of fact, during voir dire, I think every juror recognized and acknowledged that occasionally children lie. However, those 12 people hear all the evidence and believed the defendant or believed the victim, which is their role. Identity and credibility were the basis of the defendant's theory to raise reasonable doubt, but a jury disagreed. As to judicial conflict of interest, any court of law in the state of Michigan has inherent authority to punish contempt, whether direct or indirect. On June 27th, 2022, this court heard a bond argument which was denied. At that hearing, the defendant stated, quote, "Y'all on some straight bullshit, I swear to God, bro," and then said, quote, "Suck my dick, fuck you, bitch ass." He then got up and walked away from the Zoom hearing. On August 1st, 2022, at the next court hearing, the defendant was found in contempt, and I took his sentence under advisement pending resolution of the trial, at which point the defendant stated he wasn't talking to me, and even if he was, he had, quote, "freedom of speech." Mr. Allen Bass, what is said in court and before the judge does matter, but it doesn't necessarily make me prejudicial or prejudiced toward you. You're not the first person to say vulgar things to me. You're not the first person to insult me. And candidly, at this point, the reason I didn't sentence you for contempt was because I wanted the process to play out with 12 jurors who heard evidence and rendered a verdict. So there is nothing personal between us, sir. I took the contempt proceeding under advisement for the purpose of sentencing you. The First Amendment is not a shield to use in the case of clear, unambiguous contempt, and a court acting consistent with authority is not a basis for a new trial. Again, 12 jurors decided your guilt, not me. The jury never even heard about the previous contemptuous behavior. So your motion for a new trial or directed verdict filed through Mr. Killewald is denied. So, sir, the question is, are we prepared to go to sentence today or no?
I want to get their hearing on the record. That's all I'm asking for.
Okay, so I'm going to adjourn the sentencing in this matter to April 26th, and I'm going to require that you be here in person, and we will take up these matters then.
I want to get their hearing on the record. I will not be there.
Then I'm not available on the 26th.
Okay, well,
Richard,
that's the next week.
We
can't do it the next week, but we can do it the following.
How about May 3rd?
May 3rd?
I wish it were tonight, Your Honor, but that's fine.
I plan to be here on May 3rd, so let's do it then. We don't need to inconvenience you two in any way. So
May 3rd to be fine. Does my client need to be in court?
he will be in court, yes.
I want to prejudice him more of an inconvenient judge.
It's not an option at this point because he will be sentenced at that time. Sure. Okay, we are back on the record in People versus Richard Allen Bass. Two files. One is 22-44FC. The other is 22-239FC. This is the date and time set for sentencing in the matter. I will note that there was a bench conference with both the prosecutor and defense attorney. There was obviously robust discussion between the court and the defendant as well. The defendant has left the hearing, and so there's nothing I can do about that. However, after discussing this at the bench with counsel and some concern about delays, I am going to adjourn the sentencing on both files until tomorrow at 11:30 a.m., which would be April 13th at 11:30 a.m., and I am ordering the defendant be brought down in person for the sentencing, and I will contact transport and make sure that happens. Okay?
You want Mr. Killewald to prepare an order denying the motion for new trial?
I do, yes. Well, did you want Ms. Reiser to prepare that motion? Of course you're ready to do that, Mr. Killewald. I know.
That's one.
And with that, that case brings to an end. Our kitty fight for today also comes to an end. So we will bring it there. As always, come on back tonight for more fun and probably some substance as we continue to march along here from day one. Have the best of afternoons. We will see you all tonight.